Hi, my name is Joe Esquivel, and I'm with Mortgage Compliance Investigators. And today's video is on Res Judicata, a double-edged sword. What does this mean, Res Judicata? This term is heard time and time again. However, I believe that few have an understanding of what it is that is being said. In layman's terms, it literally means a matter judged. Res judicata is a principle that a matter may not generally be relitigated once it has been judged on the merits. If you have additional issues that were not brought forth prior to the case being adjudicated on the merits, then you will be barred from bringing forth any additional issues. Holding your cards close and worrying that the opposing side will get an advantage if they see all of your cards will hurt you more than help you. This is called claim preclusion. If you are going to come forth and state that controversy exists between parties, then in this writer's opinion, you should throw everything, including the kitchen sink, at the opposing side. You are not going to hold back. You are setting up your case to go to the appellate court. At the appellate level, you articulate each and all of the arguments that have been ruled on from the lower courts. You will not be allowed to bring forth any new information or arguments. Pursuant to res judicata, you will only be allowed to argue adjudicated matters that have been ruled on from the lower court. When we're talking about issue preclusion or collateral estoppel, that is where once an issue of fact has been determined in a proceeding between two parties, the parties may not relitigate the same issue, even using a different cause of action. Example, if one were to get an order from a state district court where a determination had been made that a document purporting to be an assignment of deed of trust was ineligible to be recorded pursuant to statutory requirements of law, this order from the court would ask that the assignment of deed of trust be declared a nullity and that the lien encumbering this property be removed as barring all named parties within the order from any future actions pertaining to title to the property. The parties named in the order would be unable to come forth with a future action pertaining to title as a determination had been made based on the merits of law that have been adjudicated. In setting up issues pertaining to what is to be adjudicated, the parties that may or may not come play in your sandbox takes finesse in doing these issues, and when properly done will leave you smiling. Remember when using res judicata to use both hands when wielding this sword. Thank you.